Good evening, everyone. Can y'all hear me?
Yes.
Okay.
Yes.
Yes.
All right. Okay, we're not going to be on here very long at all today. Did everyone get the link to tonight's forum or panel discussion that I'm offering for if you are present there and shoot me a direct message in the chat. You'll get extra credit. So it just needs to be in that chat. Just let me know. Just post your name or send me your name so I'll know you're there. All
Did
right.
you email the link?
I posted it as a announcement in the Blackboard. So if you go to Blackboard, it's in the announcement. So I know when y'all get announcements, I click email, so it should have been emailed to you when you got the announcement. But if not, just go to your announcements in Blackboard. So let me do the call the roll real quick. Let me see, Jayla Armour. I think I see you, Jayla. Jayla Armour, I see you up there. Got you.
Yeah, sorry, I'm here.
Laura Blackstock. Alice Bota. Adiva Brown. Chanel Burrows. Megan Carter. I think I see Megan.
Here.
All right, got you. Samar Daniels. I think I see you down in the corner. You here? Yep. Got you. Jayla Davis.
I'm here.
All right. Key Landria Dodd. I think I see your name.
Yes, sir, I'm here.
All right. Sydney Graham. Sydney Graham. Okay. Sydney Hatmaker. I think I see you. All right. Chloe Jones. Nope. Jada Lanier. Nope. Ashley Little. Nope. Kiana Littlejohn.
I'm here.
All right. Cameron McCain.
Here.
All right. Lastacia Miller. Nope. Jermaine Mitchum. Don't see Jermaine. Anaya Roberts. Nope. Chantel Shan. Who's that on the iPhone?
Here.
That's
It's Chantel Shan.
Okay. Is my connection breaking up?
A little bit.
Okay. Courtney Shannon. Jaquan Smith.
Here.
All right. Is my connection better now? Okay. Daphne Smith Sanders. Nope. Jeremy Vick. Nope. And Tavis, I got you. Can y'all hear me? Am I breaking up?
Yeah, a little bit.
All right. Let me move and get closer to the wireless. Is this better now?
Yeah, that's good.
Okay. I gotta get a wireless extender in my office. Okay. So where am I? Okay. The chapter we're going to talk about very, very briefly tonight is chapter 11, the civil and criminal remedies for constitutional violations. So we learned in chapter 10 about the exclusionary rule. The exclusionary rule being a court-made rule that essentially says that if a court deems that a person's constitutional rights were violated in the investigation of a crime, that whatever evidence is obtained will be excluded. And that is exercised through motions, through what we call suppression motions to suppress evidence. So if a court finds that in a suppression motion that evidence against a defendant was obtained illegally and violative of their constitutional rights, then the first remedy the court has is to throw the evidence out. Now, there are other remedies as well outside of court. So sometimes a person's rights are violated, and based upon the level of the violation and severity of the violation, they may have other stuff outside of just the exclusionary rule. They may be able to sue, or in certain situations, they may be able to, the law enforcement that is that exercises or that in the exercise of their duty, if law enforcement violates a person's rights, that individual law enforcement officer or officers may be charged criminally. So it just depends. So normally, let's say what we've been seeing a whole lot of is use of force, use of deadly force specifically. So it goes back to the Fourth Amendment. When we talk about Fourth Amendment, is reasonable searches and seizures based upon probable cause, right? Hold on. Yeah, it's reasonable searches and seizures based upon probable cause. So, and upon probable cause, the warrant is going to be issued. So we look at the Fourth Amendment. It has multiple requirements. The first requirement is that there be a warrant, and that warrant be established, be given based upon the establishment of probable cause. So there must be probable cause first. Now we talk about certain exceptions to the warrant requirement, where they don't have in certain exceptions or exceptional cases or situations, the law enforcement does not have to go get a warrant as long as the probable cause is apparent. Pretty much most of the exceptions to the warrant rule involve something being apparent, or there being apparent probable cause. Either there being an arrest made, where at that point, if there's an arrest made, there's now probable cause to arrest. Now we can also search you. Or plain view doctrine, where we're looking at you commit the crime, so now we can arrest you and search you. Or whatever the let's say plain view doctrine, being that you have contraband, or we're watching you with the cocaine or with the weed or smoking crack, and we see you doing it. That is an example of what we call the plain view doctrine. So that's an exception. But in all those, a probable cause must be established. Either you have to go get a warrant that's based on probable cause, where you have to explain the basis of probable cause, or at some point in time, if it's an exception, you're still going to have to explain the basis of your probable cause, but your probable cause is immediately established by what the law enforcement officer sees, so they can now either search or arrest without getting a warrant. So when we say search and seizure, search means search when they're searching your home, searching your person, running your pockets, and seizure means to arrest or to take control of one's body. So the ultimate form of seizure is use of force. So a use of force, that is law enforcement officer physically taking control of one's body. They can do it by roughing you up, by putting handcuffs on you and arresting you, or they can do it by possibly using deadly force. So deadly force is a form of seizure. As a matter of fact, in certain situations, it's called the ultimate form of seizure, because it is dead. When they use deadly force, they're essentially killing you. So they're seizing you. They're essentially seizing your life. So with all that, probable cause must be established, and there's a rule that requires it to be reasonable. So the search must be reasonable in situations where probable cause. So even if there is probable cause, there's still whatever search is done has to be reasonable. Even if there is probable cause, whatever arrest is being carried out has to be done reasonably. So it's not just probable cause and a warrant or probable cause. There's probable cause and whether it's a search warrant or an arrest warrant, it has to be carried out in a reasonable manner. So of course, when we're determining what reasonable is, we have to look on a case by case basis, right? And the totality of the circumstances. So there are certain situations where deadly force is used, and if deadly force is used and it's deemed that that person's rights were violated in the use of deadly force, there are civil remedies. As a matter of fact, not even when deadly force is used. As a matter of fact, sometimes even when non-deadly force is used, when the cops rough somebody up, like the Rodney King case, in those situations, there are civil remedies. So civil meaning that you can file a lawsuit against the entity or the entity over the law enforcement agency. So in most situations, that's the city. So most law enforcement agencies are local, and there is essentially city organized, a city run. Like it's the Greensboro Police Department. They're run by the city of Greensboro. In the Breonna Taylor case, it was the Louisville Police Department. So the city of Louisville is essentially over the police department. So that means in the Breonna Taylor case, of course, the family has the right, because they're claiming that Breonna Taylor's civil rights were violated, or her constitutional rights were violated, because essentially what they did was tantamount to a seizure. It's the ultimate seizure. They took her life in the search. So even though they had a warrant that was based on probable cause, in exercising the warrant, it still had to be done within reason. So it had to be reasonable. So at the point that it was not reasonable in the way they carried it out, Breonna Taylor's family has the right to file a lawsuit. So that is a form of remedy. Now, we're going to talk about the Breonna Taylor case a little bit more, in about an hour, and a little bit more than an hour, on the panel. But from a standpoint, the city knew that rights were violated. Now, there's, because the city knew their rights were violated, and Ben Crump, as the attorney for the family, he essentially filed a lawsuit right away, and without even blinking an eye, roughly so it happened in March. She was killed in March, and by August or September, roughly 6 months out, the city had already said, we're going to cut the check. We're going to settle this. We don't want to go to trial. Cut a big check. So what that means is the city knew that we are at fault. So the city cut the check, and to the tune of $12 million. Now, this is going to be talked about on the panel a little bit. Professor Makumbe is going to be the one talking more about this side. But for a city, a lot of times when you're suing a city based upon something that law enforcement does, cities are stingy. They normally don't cut checks in the millions of dollars without a fight. And 6 months is like the blink of an eye in the civil process when you're filing a civil lawsuit and you're going to trial. Most civil cases, whether it be against a city or whatever other entity, most civil cases, you file a lawsuit, there's a back and forth period where both sides are trading information, you're trading filings. You filed a lawsuit, we now filed an answer to the lawsuit. So just that, once a lawsuit's filed, the opposing party that's being sued has 30 days to respond. So that's a month right there. Then once they respond in the lawsuit, then of course the opposing side, depending on what they respond with, they now have to respond. So then they have 30 days. And a lot of times, those 30-day periods, they're usually motions to extend the deadline that are filed. So I mean, in most lawsuits, because I've handled lawsuits before, there's always at least one extension, probably on both sides, right? So usually that you're talking about 3-4 months before we even get to it, before we even get to the point where we're answering each other. And normally that there's an amount of years sometimes that can go by before we ever get to the point where we might touch a courtroom. So it is astonishing and amazing that in 6 months, now 6 months is usually a period where all we're doing, all the sides of a civil lawsuit are doing nothing more than trading paper, and filing for extensions. In that little 6 months, the city acted quickly and they said, "Yep, we're gonna cut the check." What that meant is the city essentially said, "Yep, some wrong things were done here, and we owe them money." Of course, money can't bring her back, but we're gonna cut the check. Now that is a civil remedy. Now, there's certain federal, and I talked about them at length in my lecture, and everybody understood the lecture, right? I know this is one of the chapters I kind of don't like teaching because it's super boring. But did y'all understand the lecture? Hello, somebody?
Yes.
Okay.
Yes, for the most part.
All right. So I think I talked about the Section 1983 lawsuits. Those are civil rights lawsuits under federal law. So you're essentially suing based upon federal law, a federal statute. So there are other federal statutes. Then you also have state statutes where you can sue for violation of evidence, but primarily it's done through federal courts. So a family, or a person like Rodney King, people don't realize Rodney King, he was roughed up by the cops. Well, I'm gonna say more than roughed up. He was beat down. He called a beat down. In that situation, in the Rodney King case, the law enforcement officers who were the perpetrators of that crime, they were charged. They were indicted. So the district attorney indicted the case, and they went all the way to trial. Now, once they went through a trial, they ended up being acquitted. But the city of Los Angeles was still on the hook for the actions of those officers. So there was still a lawsuit that was filed. And even though those officers were found not guilty, the city was still sued, and they still had there was still a payout that had to be paid to Rodney King. So he was still paid on the civil side, but that's different. Rodney King lived to tell about it. He was breathing, right? So he lived to enjoy the lawsuit and get in that money. It's different in the Breonna Taylor case because yes, a lot of money, a big check was cut in a astronomically fast amount of time. But Breonna is not here to enjoy that money. That's essentially death money. And it won't bring her back, right? So in the Breonna Taylor case, of course, we know that the law enforcement officers were not even indicted. And I'm going to talk about that on the panel. But yeah, they were not indicted. So if they were indicted, that means those officers individually would be charged criminally for their conduct. So like the chapter says, civil and criminal remedies for constitutional violations. So what that means is law enforcement for violating your constitutional rights in certain situations. Not only can the law enforcement office be sued, or the jurisdiction that runs the law enforcement, like a city or a county. Not only can they be sued, but individual officers for their actions can be held criminally liable, can be charged with the crime. So of course, being charged with the crime, they got to go through the process just like a regular defendant. So they have to go through the process of indictment. Are they going to be, or is the grand jury going to issue a true bill for indictment, or are they going to give a no bill? And if they do give a true bill, all that means is there's probable cause to move forward, and that it's essentially the grand jury giving the district attorney permission to pursue and prosecute the case further in a superior courtroom. So in that situation, it still doesn't mean that the prosecution of the case is going to be successful, because there can still be a trial. Just like Rodney King, those cops were, for one, it was on tape. So the whole interaction was on tape. So it was videotaped evidence of what happened, and the officers were indicted, and they went through a trial. It was a trial. Now, because those officers were defendants in that situation, they had defense counsel. They had lawyers just like anybody else that is a defendant in the situation. So their lawyers, honestly, I know we don't like them, but they did an awesome job. If I'm the lawyer for those officers, what the lawyers did for those cops was actually, from a tactical standpoint, looking at it just from a tactical standpoint, they did what they needed to do to give the officers the best chance to get acquitted. And one of the first things they did was they filed a motion to change venue. What that means is that's only something that the defendant has a right to do. As a defendant and as defense counsel for the defendant, you have a right, if you feel like a trial is not going to be fair in the jurisdiction that the person is charged in and going to be tried in, you can file, only the defendant can do this, can file a motion to change venue. What happened in this situation is, because the officers, they were cops when it happened, their defense counsel made the argument that it wouldn't be fair to have a trial where it happened, because of everything that's going on and the tension. They said it wouldn't be fair to have a trial where it happened. So what they ended up doing is they actually got the venue changed and got the trial moved to a jurisdiction that probably was maybe less than 10% black. So essentially the whitest part of it was a county outside Los Angeles. I want to say it was Simi Valley, if I'm not mistaken. But literally, they essentially got it where they could get one of those old school 1950s juries that were all white, essentially. So they moved it to a neighborhood that was not connected to what happened. I mean, they moved it to a jurisdiction in a county that was not connected to what happened. Now, if they're able to stay in Los Angeles, where it happened, the likely, at least, not saying it would have been unfair, but at least it would have been a jury that would have been a jury pool of Los Angeles natives, people that live there, pay taxes there. And now I guess the argument they made is that because the case was so publicized and the video was out there and it had been made public and everybody was looking at it, that the jury pool would be essentially the jury pool would be tainted in Los Angeles, so they wouldn't be able to find jurors that didn't know anything or could kind of separate what they're seeing on TV from what their job they have to do in the court of law. So that was their argument. So they got the case moved. So the officers were still tried, and surprisingly, they were acquitted. I think one officer got convicted of something like some type of misdemeanor or something like that. But still, they pretty much got off. So that's an example of when law enforcement, when they violate your rights, they can be charged criminally. So the civil remedies, meaning you can file a lawsuit to be compensated for the violation of rights, or in certain situations, law enforcement can be charged with crimes for violating rights. So when we talk about use of force, remember this, we're always talking about the Fourth Amendment reasonableness requirement. So even if they do have a warrant, the way they exercise the warrant, the way they arrest a person still has to be reasonable. So of course, that's what we're talking about. That's the rule we apply. So don't just think about the warrant and whether the warrant was right or whether there was probable cause in the warrant. Even if there is probable cause in the warrant, even if Breonna Taylor was standing outside her house that night smoking trees, it would have been illegal, but it wouldn't have given them probable cause. It wouldn't have given them the right to kill her. So just because they had probable cause to search, doesn't mean that she was in the wrong or to a point where she deserved to die. So that's essentially what that means. So by using deadly force, they violated her rights. And it's obvious that the city of Louisville recognized that early on, because they didn't even want to go through the process of trial. They said, yo, go ahead and cut the check quickly. So that is an example of the civil and criminal remedies. So of course, in my lecture, I talk more about what exactly those remedies are. But I'm not going to go through it tonight because I've already given the lecture. Just read the book and and look at the lecture. So I go through all of it. So for next week, actually tomorrow, the 29th, chapters 12 and 13. The links to the lectures will be posted at 7 a.m. So your reading assignment for this week is chapters 12 and 13. Then next week on the 4th, we have our Zoom number 10 where we're going to talk about chapters 12 and 13. So we're counting around in the corner. We only got a few more chapters left. Actually, next week as well, I want you guys to get prepared because we have our Zoom meeting on the 4th, but on the 5th, that Thursday morning, the second writing assignment will be posted. So next Thursday, the second writing assignment will be posted, and it won't be due until the following Thursday. So it won't be due. So it's posted on the 5th, but it won't be due via email until the 12th. So I just want to give you guys a heads up on that now. So that's what's coming up next week. Is of course, I don't know if everyone was here when I announced it at first, but tonight there is an extra credit opportunity. I posted in the announcements for the class the link to we're having the Breonna Taylor student and faculty panel this evening where we're going to talk about the case. We're going to talk about the case from a faculty perspective, and we have some students that are going to chime in as well. So be there and you'll get 5 points. The way I want you to prove that you're there, listen to me carefully. As we're in this Zoom now, of course, everyone can send each other direct messages in the chat. When you're in there, what you do is you send me a direct message with your name. Just say your name, and I know you're there. Just type out your name, and I know it's you because some of you on iPhones and stuff, or some of you got nicknames. So just type to me in the chat your name, and I'll write it down. That'll be me. That'll be you saying I'm here. Now, a lot of times everyone comes at me real fast, so as fast as I can, I'll try to reply and say I got it. But if I don't say I got it, I actually have it. You'll see me jotting down. But you gotta think there are 15 people in here. I got other classes as well. So imagine everybody from all my classes hit me at the same time. I'm not going to be able to move fast enough to reply to everyone. So as long as you send me the direct message, I got it and we're good. So those are all the announcements for tonight. Like I said, do your reading and look at your lectures and you'll be fine. So any questions before we log up out of here? Okay. I'm not breaking up, Emma.
No, you're fine.
Okay,
Go
good.
ahead.
Somebody hit me in the chat. Hold up.
Also,
Okay.
did you get Sydney Graham for attendance?
Let me see. I think I got you. Yeah, I got you when I saw you sign in. Laura Blackstock, I got you as well.
Yes. Thank you.
I saw you sent me a message as well. So Daphne Smith Sanders signed in late. I got you. Hold up.
I'm here.
I got Daphne. Who else signed in late? I feel like it was somebody else.
Chloe Jones.
Naya Roberts.
Nia Roberts and Chloe Jones.
Yes.
I got Chloe Jones and
Can you email us the link to the Breonna Taylor discussion?
it's in the go to Blackboard.
Mm-hmm.
So when you go to Blackboard, it's going to be in the announcements. So it would have been the last thing I sent you in the announcements for the class. As a matter of fact, I just sent them out I think I just sent it out Monday. So if you go to Blackboard for the class, and it'll be in the announcements.
All right. Thank you.
All right. Anybody else need to check in? I think I got everybody, but I just want to make sure before we log out. All right. Well, you guys be good. Take care. See y'all next week.
Tonight.
Oh, tonight. Yeah, you're right. Tonight. Well, I can't make you come tonight as if you want the extra credit, but I'll definitely see you next week.
Well, that's interesting tonight.
Because I want to say for that.
Okay.
Yes.
Well, the link is not going to be on this Zoom. It's going to be on another. So go to the Blackboard if you don't already have the link and sign. It's a different Zoom. So it's not this class Zoom. It's different.
Okay.
Yes, sir. Thank you.
All right.
See you in an hour.
See you now.